afternoon and welcome to the first residential conveyancing forum for Northern Ireland for 2025. Another year has come and gone, and if it's not too late, Happy New Year to you all. And we've got Ian to talk about some more topics today, but as always, it's your contributions that really matter in these forums. So we want to know about your experiences, any problems you have seen, and obviously if you've got a solution to problems that are raised, please let us know about those. If you could put your comments in the chat feature or else raise your hand, we'll try to unmute you. But in the meantime, if everyone could be muted, and I will do the same and hand over to Ian.
Thanks very much. So massive thank you to Stewart today for inviting me along, and welcome to everyone in Northern Ireland. A few bits of housekeeping before we start. Stewart and ourselves are very keen to do some face-to-face training in Northern Ireland at some point during 2025. So really interested as to whether or not you would be interested in coming along. I used to do loads of work for a company called Central Law Training and used to come to Belfast twice a year to do training, and I loved it. We used to get loads and loads of people attending. So really interested if you give us some feedback with regards to that during the course of today. As far as these forums are concerned, what we like to do is to use the chat facility as a means of communicating. We are, however, able to turn your microphone on if there are any things that you'd like to say or any contributions you'd like to say sort of verbally rather than using the chat facility. But the chat facility seems to be the best way of communicating effectively. If you're not going to speak, please keep your microphones off so that we don't get any feedback or any issues. So as far as topics today are concerned, a few things that I'd like to talk about. First of all, do have a look at Stewart Title's products and policies with regard to online and bespoke policies. Talk to John, Liz or Robert about your needs and requirements. Contact details on slide. As far as my topics are concerned for today, if you just skip along. First thing I want to talk about is climate change in resi conveyancing and indeed in commercial property work too. The reason that I mention this is that the Law Society of England and Wales is about to publish guidance for residential conveyancers concerning climate change. And I do think it's important that we understand and appreciate the significance of climate change in the conveyancing market, to understand what our role is as a resi conveyancer or indeed a commercial property lawyer in connection with climate change, and to draw to your attention the availability of climate change reports, either an isolated report or alternatively alongside an environmental search and report. So my first question to attendees today is how many people in a resi transaction would draw to their resi clients' attention the availability of climate change reports? Equally, if you're doing commercial work or you do mixed use work, would you talk to a commercial client about it? So do we or don't we refer to climate change reports? And again, if you could put your answer in the chat there. As far as the Law Society of England and Wales is concerned, it recommends that conveyancers advise their client about the availability of report. Now, there was some debate about whether or not a conveyancer could be negligent if they failed to advise the client of the need to obtain a climate change report. The barrister that dealt with that is a KC called Stephen Troman KC. And Stephen, if you actually read his opinion, says you're not negligent if you fail to obtain a report. You could be negligent if you fail to advise a client as to its availability. So again, no one's answered yet in the chat. Anyone currently advising a resi client about the availability of a climate change report? And again, in a commercial context, are you raising it? My view is that you should draw to a client's attention its availability. If the client wants a climate change report, then all you are required to do is simply advise the client that there are potentially 3 types of risk relating to property ownership and climate change. First risk, physical risk of damage to the property. Second potential risk is what's called a transition risk. The risk of the Northern Ireland government legislating and requiring electric vehicle charging points in a resi property as a compulsory requirement, changes in connection with uses of heating, so changes from gas or oil to heat source pumps and this sort of thing. other legislation involving all manner of different energy efficiency requirements and obligations. So when we talk about transition risk, it's notifying the client you're buying a residential property, you're buying a commercial property. Climate change is a real risk with regard to property ownership. And not only is there a physical risk to your property, but there's also a risk that you as a property owner are going to be compelled into undertaking measures which mitigate or eliminate the risk of climate change. The final type of risk that's referred to is litigation risk, the risk of you buying a property and, for example, climate change affecting your property that damages my property alongside. So really interesting stuff. No compulsion as far as Northern Ireland is concerned. But as I say, I think it's something coming down the tracks for you. And it's something that certainly is of concern to resi conveyancers in England and Wales. The English Law Society gave guidance back in 2023 of a general nature about climate change for solicitors. There's new guidance which is due out any day now concerning climate change and resi conveyancing. I'm told by someone that's seen what is likely to form the basis of the Law Society guidance that all they're doing is drilling down on those three types of risk. As a resi conveyancer, your task is simply to highlight to me, if I'm your client, about the availability of climate change report and a general explanation of the types of risk and a recommendation to the client that if they have any questions or queries relating to climate change, that they ought to speak to the provider of the report that you have obtained on the client's behalf. Not on the list, but that leads me to something else that's worthy of discussion. Robert Kelly and I have attended a few conferences over recent months and events over recent months. And one of the things that we've been speaking about is due diligence in resi conveyancing and the fact that there are search providers that will carry out searches on our behalf, or more accurately on our client's behalf through us. And to what extent is it necessary to explain to the clients the available searches? So, of course, in any transaction, there are necessary searches, but should we then be saying to the client, here's a list of the searches that we need to do, but also here's a list of the searches that we could do. So I'm going to ask Mildred and Jeremy and Jerry, if I was a resi client of yours, you're going to tell me about the searches that you're obliged to do as far as due diligence is concerned. But would you also say to me, hey, Ian, not necessary, but here's a list of other searches that we could do in connection with your property? Anyone got a view on that? Can I tell you that when I discussed it in conferences, I normally get pushback from practitioners. And what they'll say is, if I say to every client, these are the searches that we've got to do, but here's a list of all the searches that we could do, I'm going to be bombarded and inundated with questions about why you're saying they're not necessary, why you're telling me about them, what do they involve, what do they cost, etc. So the vast majority of resi conveyancers are saying, no, we're not going to tell the client about all the searches we could do. The sort of halfway house that we've left this on is to say to clients, these are the searches that I've got to do. Be aware that there are other searches that I could do. If you have any particular purpose, if you have any particular concern about the property you're buying, let me know. And there may be searches, or there may be inquiries, or there may be reports that I could obtain that might assist you with regard to the decision-making process as to whether or not you're happy to proceed or not. So again, anyone got any views on that? What do you say with regard to searches? And the same thing with regard to inquiries. It's always possible to raise additional inquiries before contract. Do you let the client know about that? And again, in a resi context, would you always ask client about their objective? So why are you buying this property in the middle of Belfast? Is it a buy-to-let investment? Are you going to be living in it? Are you going to let it? Are you going to demolish it and reconstruct or refurb it? Just what are your plans? And then determining what due diligence looks like in connection with that objective. I think that's important. The next thing I want to talk about, anyone got any comments on that, by the way? So do just keep an eye out and just be aware that there are climate change reports that you can obtain. A lot of the environmental search and report providers will bolt on climate change and are already doing that. So again, just be aware of it. I'm not saying that you're obliged to give advice relating to climate change. I'm saying your role is simply to make clients aware of the fact that a climate change report is available. Before I talk about proprietary estoppel, here's something that's really interesting that was put to me recently. How about this one? Has anyone ever had a surveyor or a client asking you about issues concerning aviation and flight paths over a property? A firm contacted me late last year and said that they'd had a surveyor's report in from a client who said, ask your conveyancer to check with the Civil Aviation Authority air paths over the property that was being acquired, on the basis it could generate issues associated with noise. I have had that as an issue where you're buying a property close to an airport, but I've never had it just in, in a rural location. And I was asked, well, what should we do about that? You can ask the Civil Aviation Authority about flight paths, but it's not your job as a conveyancer in a standard resi conveyancing transaction to undertake investigations in that regard. And my view is, if a client or a surveyor asked you about it, you'd say it's not within my retainer to give advice on that area, but you can, Mr. Client, contact the Civil Aviation Authority and find out for yourself. In England and Wales, interesting point, if your property is near an airport, a local land charge might be recorded in your local land charges search, in your local search, restricting the height of buildings on a plot that's being purchased on the basis that you're on a flight path that is approaching an airport, and therefore there are restrictions on the height of buildings in that on that flight path. So it's something I've never encountered before. It's funny with conveyancing, isn't it? Every day there's always something new, and you always learn something. Okay, proprietary estoppel. Just a note that there's been quite a lot of case law relating to proprietary estoppel. It is very much alive and well. Remember, generally speaking, for a contract for the sale or purchase of land, the agreement must be in writing. However, proprietary estoppel generates an equitable interest in circumstances where a promise is made to you concerning land. Your client acts to their detriment as a consequence of the promise that's made, and in those circumstances, if the promise relates to land, the person making the promise can't go back on their word. The interesting thing about proprietary estoppel is that the courts are for saying that this issue of acting to your detriment on the strength of the promise, the concept of what is detriment is very wide. So it's not just the issue of sustaining some form of financial loss or incurring some form of financial liability as a consequence of the promise. It could be sort of foregoing education or foregoing an opportunity for work or a career or something of that nature that would be sufficient to establish detriment. Next thing I have on my list is co-ownership and shared ownership. Anyone had any issues relating to co-ownership and advising clients relating to it? Again, a hunting ground for claims, to be honest with you. So always worth just having a look at the agreement relating to co-ownership and just making sure the buyer client understands the commitment and obligations that co-ownership generates. Anyone had any problems with regard to that? Remember what Robert said earlier. Today isn't just let's talk about what Ian wants to talk about. It's let's talk about whatever you wish. So if you've got any burning issues, burning questions, anything you'd like to share with the delegates that are attending today, or anything that you'd like us to talk about in the future, let us know. One of the things I'm very conscious of is getting speakers are coming along to events, and we are organising that. But if you've got people that you'd like to attend, you've had issues relating to matters, and there's someone that could come along and assist with regard to those issues, let me know and we'll get them along. So anything from sort of professional indemnity insurers, search providers, you name it, we can come along and talk to you about issues. I will get at some point during the year Stewart Title to sort of major in the event and to discuss defective title insurance in Northern Ireland, the products, etc., that are available. But you do have today John, Elizabeth, Robert, and the team from Stewart Title, all of whom are sort of raring to go with any burning questions, issues, or requirements relating to defective title insurance. So if you have any questions like that, put it in the chat, and I'm sure John, Elizabeth, or Robert will have a look at it. And if necessary and appropriate, I'll put my 2 pence in. Next issue I've got is connection with co-ownership. And the reason I mentioned co-ownership today is I was talking to a professional indemnity insurer last week, and he was showing me a number of claims or notifications relating to claims concerning co-ownership. And there's some basic principles with regard to co-ownership that I want to share with you. Firstly, and importantly, why does co-ownership in resi conveyancing cause negligence claims? In my view, and in professional indemnity insurers' view, the reason that co-ownership causes negligence claims is twofold. One, lawyers make assumptions. So husband and wife selling a property, buying another one, current property owned as joint tenants in law and in equity. Therefore, no choice. That's what we do with regard to the new purchase. Two business partners buying a property with unequal contribution as a buy-to-let investment. The property is purchased as tenants in common. Well, yeah, both of those things would make perfect sense, presuming that we've got full information from the clients before being able to confirm just what the position is. So, one, do you use a co-ownership questionnaire? Do you send that out to the client with an information sheet explaining choices that are available to the client, explaining that in order for you to give appropriate advice with regard to co-ownership, you need to know their circumstances? Have they been married before? Have they got children from previous relationships? What contributions are they making to the property with regard to initial purchase? What contributions will they be making with regard to ongoing costs? All of these issues are important. Why? If clients are or have been in relationships in the past and have children from previous relationships, then they may have a will in which they are gifting their assets to their children. In those circumstances, if the major asset of our imaginary client is a half share in a matrimonial home or in a home that they're setting up with a new partner, if that property is owned as joint tenants in law and in equity, then that half share is going to go to spouse or new partner and not vest in the children in accordance with the will. Now, that may or may not be unfair. With regard to the same principle, you could have a scenario where parties are making unequal contributions with regard to the purchase, and yet they're, for whatever reason, wanting to own the property as joint tenants in law and in equity, meaning a 50-50 split of beneficial interest. If that's the case, you should be saying to the client who is making the major contribution, well, in doing what you're suggesting, you are gifting a share of the beneficial interest to your spouse or partner. And that may be perfectly acceptable at the moment when you are in a stable and happy relationship. But if the wheels come off that relationship and it breaks down in the future, you're not going to be very happy, or you may not be very happy, on the basis that you have, in essence, gifted a share in the property, an interest in the property, something of significant value to a person that you're now at loggerheads with. And again, the other thing to explain is, of course, that if parties are married or in a civil partnership, then no matter what the beneficial interest is or how it's held with regard to the property ownership, that could be overturned by a court in connection with proceedings relating to the breakdown of that marriage or civil partnership. So, questionnaire sent out to the clients relating to co-ownership, important. Information to clients about choices. Information to clients about the law relating to those choices, important. Let's drill down on some of those issues. Joint tenancy in law and in equity creates an equal division of beneficial interest, number one. It generates the doctrine of survivorship, number two. However, the doctrine of survivorship is interesting in that it is possible, of course, to sever a joint tenancy. Over recent months, I've done lots of work with firms looking at their standard retainers, their engagement letters to clients. And one of the things I've noticed is that we're a little bit shallow with regard to advising clients about co-ownership. In that, what firms seem to do is to fail to tell clients that, one, if you create a joint tenancy in law and in equity, it is possible for either party to sever that joint tenancy unilaterally. So we don't need consent, we don't need a court order, we don't need anything. Our imaginary client could write to the others saying, we bought this property as joint tenants in law and in equity. I'm giving you notice as of today that that joint tenancy is severed. And that's it. So there was a negligence case involving that in England a few years ago, where someone attempting to be magnanimous and generous purchased a property using his resources and said to his then partner, I think that as we're in partnership together, we should own the property as joint tenants in law and in equity. Unfortunately, our man wasn't quite being as magnanimous as was as first appear. He knew that his partner was ill. He knew that the chances were that she would not outlive him, and therefore his generosity would be paid back at some point in the future, as she was likely to die before him and he would get his half share back. Unfortunately for him, two things happened. One, his partner was switched on and realized that in owning the property as joint tenants in law and in equity, the position could be immediately altered by severing the joint tenancy, which is what she did. And then, unfortunately for all concerned, she died shortly thereafter. The gentleman concerned, therefore, lost his half share in the property, in that, given severance, her half share was disposed of via her will. And so what our poor unfortunate gentleman did was bring proceedings against his solicitors. He sued them in negligence, saying, had you told me that my former partner could sever the joint tenancy immediately after the joint tenancy was created, I wouldn't have done what I did. So the matter went before a High Court judge, who said, well, yeah, prima facie, your lawyers were negligent. They should have advised you that the joint tenancy could be severed by some form of unilateral act or words. And in doing that, your joint tenancy would immediately be terminated and a tenancy at will in equal shares created. As a consequence of a failure to do that, your lawyers were negligent. Now, unfortunately, again, for the gentleman concerned, he lost his case on a limitation point. But when I saw that case, I thought the profession needs to understand the importance of unilateral severance and the consequence of that with regard to joint ownership, joint tenancy in law and in equity. And the other thing that I think, again, people should be aware of is death as a consequence of common accident. So in those circumstances, if two people own the property as joint tenants in law and in equity, the younger is deemed to survive the elder, which could be fortunate or unfortunate, depending on what the younger person has done in their will. It is possible to revoke that principle in wills, but sometimes it's an issue that's overlooked. Where people are owning as tenants in common, are you advising clients of the need to keep any form of deed of trust under review? And are you advising clients about the significance of a tenancy in common and advising clients to have wills? Co-ownership causes problems and causes claims. It's not straightforward or simple. It does require a great deal of thought. A bit of bad news for you. There's quite a bit of case law that says advising people on co-ownership generally is not an additional service that can be charged for during the conveyancing process. It'd be regarded as part and parcel of the conveyancing process when acting for joint owners purchasing a property. So if I and my partner, or I and my spouse or business partner instruct you to act for us in connection with a purchase, you cannot say during the transaction, we're going to charge you more for advice relating to co-ownership. It will be part and parcel of your original conveyancing fee. You can charge for the deed of trust that you create, assuming you're instructed to do so, but you can't charge for general advice relating to co-ownership. I would maintain, therefore, that when you're onboarding clients, one of the things you should look out for is if you're acting for more than one party in connection with purchase and co-ownership is going to be an issue, you're going to be obliged to undertake more work, and therefore you need to charge for the work that you're doing and make it that clear when you're onboarding the client. The other thing I think that's important with regard to co-ownership is if you are creating a deed of trust, you can charge for the creation of the deed of trust. And again, issues can arise in circumstances where you're instructed to draft documentation, which is inconsistent with what the party's actual contributions are. If you're instructed to proceed on that sort of basis, I would warn the client that, look, we're potentially storing up problems with regard to acrimonious divisions of assets at some point in the future. What do I mean by that? If we're creating a co-ownership where the documentation reveals a 50-50 split, joint tenancy in law and in equity being the obvious one. But the reality is that one of our parties is contributing 80% of the purchase price and the other only 20%. If that relationship breaks down, one party will be saying, if there's litigation, there's the transfer document that shows this is a 50-50 split. And the other will be saying, well, yeah, that's what the documentation shows, but the reality is I paid 80% of the purchase price and my former partner paid 20%. Well, in those circumstances, what a court will do is normally go with the documentation. So proceed as per the transfer, unless there are exceptional circumstances. So the party that's trying to circumvent the transfer document is likely to fail. And the last point on this, well, two last points I want to make with regard to co-ownership. One, whenever you draft a transfer or any other document that deals with co-ownership, always highlight to the client before they execute the document what that document says. So, I'm going to draw your attention to clause 6, or draw your attention to box 5 or box 10 of the transfer document or of the lease or whatever it is, which shows that I have specified that you are owning this property as joint tenants in law and in equity, or as joint tenants in law and a tenancy in common on an 80-20 split, just to prevent a problem arising. The reason I mention that is I saw 3 cases just recently where the transfer, the conveyance, the lease had been drafted incorrectly and didn't correlate with what the client's actual intentions were. And there were 2 cases, not last year, the year before, where the parties hadn't signed the conveyance or the transfer or the lease. The buyers hadn't signed it. And then there was an argument about how the beneficial interest was held and the nature of the co-ownership. So just be careful with that. Last point with regard to co-ownership, and I want to share with you, there's a case in England last year where parties who were splitting up had agreed a division of their assets and had exchanged a series of emails. And in one of the emails, one of the parties had said, I have no interest in the property. I can't remember what the address of the property was. It was a funny name. And what the court said was, looking at the emails, the exchange of emails constituted a transfer of the beneficial interest. So the emails were regarded as being in writing for the purposes of a transfer of a beneficial interest, and therefore the beneficial interest had been transferred. So I would always advocate to co-owners that if the relationship breaks down, or if there's any plans with regard to a reallocation of beneficial interest, the client should be instructing solicitors to assist and shouldn't be exchanging emails negotiating what is to happen, because they could inadvertently transfer the beneficial interest as a consequence of the content of those emails. So be careful with co-ownership. Has everyone got a co-ownership questionnaire? Patricia, Jerry, Jeremy, Mildred, Pauline, do you all have co-ownership questionnaires that you use? If you don't, let me know. I've got a model form of co-ownership questionnaire that was prepared by a barrister, a guy called Alan Tunkel, years ago. And a lot of firms use it or amend it and incorporate it into their own co-ownership questionnaires to ensure that they're extracting all the information that they need in order to give advice. Okay, next thing, onboarding clients and assessing risk. Professional indemnity insurers are worried about 2 important things, one of which I mentioned to you the first time we did a forum for Northern Ireland, and that's something called the retainer and retainer creep. If you are scoping the retainer in a resi transaction, as you're obliged to do, it is imperative that you manage the retainer thereafter. So you're acting for me in connection with the purchase of a property somewhere out in the sticks. Okay, it is imperative that in the retainer you tell me what you're going to do, and also, and this is something I think is sometimes overlooked, you tell me what you're not going to do. So I might have expectations that you, as my residential conveyancer or solicitor, are doing certain things in the transaction, and during the life of the transaction it transpires you're going to do something that you said you weren't going to do. Well, in those circumstances you've got to expand the retainer to ensure that I understand the additional work that you're doing, the limitations relating to that additional work, and the costs that are incurred. So, all right, you're saying to yourself, Ian, what on earth are you talking about? Let me explain. You're acting for me, you're purchasing a rural property. You've told me in your retainer, when you've onboarded me as a client, that the conveyancing process involves X, Y, and Z with regard to due diligence. But it does not involve your inspecting the property that I'm purchasing. Again, most professional indemnity insurers would not want you to inspect a resi property during a residential conveyancing transaction. So you've made it quite clear that you will not be inspecting the property that I'm buying. Okay? I go out and have a look at the property, and there's an issue with regard to the western boundary. And there's a potential problem with regard to a right of way to the public highway. In those circumstances, I may make additional inquiries of the seller. You may go back and inspect the property again, but we've reached an impasse. I'm not happy with what you're telling me. You're not sure about what I'm advising you. So I say, right, I'm going to go and have a look. Or if you're my lawyer, you're saying, Ian, we'll come and have a look at the property. If in the retainer you've said you're not going to do that, and if all of a sudden you've decided you are going to do that, you need to expand the retainer, which would involve an email to me. Dear Ian, in my engagement letter, in my retainer, I said I wouldn't be inspecting the property that you're purchasing. You'll appreciate there's currently an issue with regard to the eastern boundary to the property and an issue with regard to a right of way to the property. Therefore, I've decided to inspect it. I will only be looking at the boundary issue and the right of way issue and nothing else. I will be charging you an additional fee for the additional work that I'm undertaking as a consequence of the task. And I'd ask you to confirm, or you'd ask me to confirm, that you're happy for me to proceed on that basis. So when onboarding clients, identify what you're going to do. Make sure the client is aware of what you're not going to do. Remember, unless you hold yourself out, to the contrary, your task in the conveyancing process is to identify risk, not assessing the extent of the risk. The only time as a resi conveyancer it's necessary to identify the extent of risk is where the risk is associated with title. So where there's a bit of land in the garden there's no title to, or where there's an adverse possession claim or something of that nature, you would be required to assess the extent of the risk. If you'd obtained an environmental search that revealed lead contamination at the bottom of the garden, or some other form of contaminant that had migrated onto the site over the years, it's not your job to tell me about what the extent of the risk is, or what are the chances that the Environment Agency or local authority intervene in order to decontaminate the site. Your job is simply to tell me there's an environmental search report that highlights a risk or an issue. If you want, Mr. Client, to know the extent of that risk or any issues associated with that risk, then you must contact the report provider. Same with planning. If there's a search undertaken that reveals, or inquiries reveal, a breach of planning permission or a breach of planning condition, unless you hold yourself out as an expert, as a resi conveyancer, you simply have to tell me, Ian, search result reveals, inquiries reveal there's some enforcement action being taken, or there's a breach of a planning condition or something of that nature. Is everyone okay with that? The only thing that we need to say beyond that, which I think is very important, is that there is case law that says if you become aware of anything, no matter how you become aware of it, that's materially adverse to the interest of the client, you're under an obligation to disclose it. There's a case called Bird and Bird years ago, where some solicitors did a planning search on behalf of a client to identify planning activity relating to target property. But the planning search also included issues and information about an adjoining site, and all the firm did is report to the client about the planning issues relevant to the site that was being acquired. The additional information revealed there was a school nearby that had the potential for planning for residential development. So the client wasn't told about that additional information on the basis that the firm thought, well, that's not what the search was asking about and not what the client was concerned about, which was purely the target property. So buyer client sues solicitors, judge says, sorry, if you get information in, no matter how, and this information in essence has come to you in error, you're nonetheless under an obligation to disclose it to the client. So there was a case where a judge said, High Court decision, if you become aware of anything that's materially adverse to the interests of the client, you're under a duty to disclose it. Whether you've said you'd undertake that research in the retainer or otherwise. So an example that I give people with regard to that is, let's assume you've acted for someone, 21 The Gardens, Belfast, and they bought the property at £180,000. You're now acting for someone who's buying a property in the same street, 2 doors down, and they're paying £580,000 for the property. Generally speaking, as a conveyancer, you're not under any obligation to advise clients about the commerciality of the transaction. The retainer is normally going to say that. So, as part of my job, I'm not going to tell you about the state and condition of the property. I'm not going to give you any advice as to whether or not you're paying market value, you're getting a good buy or a bad buy. The commerciality of the transaction is nothing to do with me. That's the general stance that you would take. However, if you were aware of those circumstances that I've just mentioned, as long as you're not breaching client confidentiality, you would be under obligation to say to the client, look, you're buying number 21 at 180, you're buying another property at £450,000, but I acted for someone who bought number 21, which is a similar sort of house, 3 doors down, for £180,000. Make sure that you've got a survey or evaluation that confirms you're not paying over the odds for the property. When we talk about assessing risk, always recommend to a client that they obtain a survey. Always make sure the client gets the best survey they can afford. Highlights to clients who go cheap and cheerful on survey or valuation the risks associated with going cheap and cheerful. All of those issues are important. With regard to the retainer, make sure the retainer always connects to the report on title. By that I mean you shouldn't be reporting on any issues that you said in the retainer you wouldn't be dealing with. And in the retainer, you shouldn't be saying to the client that you'll be dealing with work that you're not reporting on in the report on title. Just before Christmas, we did some work with firms, and we were looking at the use of interim reports on title. I'm a great believer in drip feeding a resi client as a transaction progresses and as due diligence progresses, the title issues that I've identified during due diligence, rather than providing the client with a full and complete report on title just before exchange. Is the client going to have time to digest all the information that I've produced in the report on title before we're due to exchange? If there is a problem with regard to the title, is it not better to draw that to the client's attention as the transaction progresses, rather than waiting until we've got all due diligence completed and then providing a report on title and including in the report whatever the problem is? I'm a great believer in providing the client with a summary in a report on title, highlighting these are issues that I think are really important in connecting with your objective. So, you're buying this property as a buy-to-let investment. Important to understand it's leasehold, and there are covenants within the lease that exclude Airbnb letting or short-term letting, that sort of thing. So, on assessing risk, your task is to highlight the existence of risk, not to quantify or determine the extent of the risk unless you hold yourself out as doing so. On issues of fees, if you give a quotation or estimate when you're onboarding the client, you are obliged to adhere to that estimate unless there's an objectively valid reason for increasing your costs. Interestingly, as far as defective title insurance is concerned, it would not be right to include the cost of the work that you undertake with regard to defective title insurance. That would not be expected to be part and parcel of your standard fee. So if it was necessary for you to take out defective title insurance as the transaction progresses, you can charge for the additional work that you undertake. If you had disclosed to you by the estate agent that the property your client was buying was burdened by some form of defect and that a defective title insurance policy should be obtained, then there would be an expectation that you'd quote for that additional work when you're onboarding the client. But otherwise, if you discover during the life of the transaction that defective title insurance policy is required, you can charge for the work that you do. Can I tell you, most firms do not charge for additional work associated with defective title insurance. Of course, the client will pay the premium, but the firm, despite the fact additional work is required relating to the defect in title and the policy, don't actually charge for it. There are some compliance issues with regard to defective title insurance. I know that Robert, John and Liz are all sort of primed and able to give your firm's training about compliance issues and defective title insurance. And to be honest, it's well worth getting that training, making sure all members of the team are aware of their duties and obligations in taking out defective title insurance, as well as the team being also able to explain to you what you should be saying to clients where defective title insurance is being taken out. I'm conscious of time. Does anyone have any burning questions, any issues? Has so far it been useful? Anyone got any questions, comments about anything I've said so far? So Josh, Jeremy, anybody, any comments to make? Just again, use the chat facility if you like, or raise your hand and speak, whatever you want to do, that's fine. While I'm waiting for that, I've got some more issues to talk about. With regard to onboarding clients, remember there's no such thing as a collective client. If you're acting for Mr. and Mrs. Smith, if you're acting for me and a buy-to-let investor along with me, we are individuals with individual needs, individual expectations, individual attitudes to risk. So it's important that you risk assess the transaction, risk assess third parties involved in that transaction, risk assess property and risk assess clients as well. And again, you will have policies relating to assessing risk. Make sure you keep them under review. Talking to a firm just at the beginning of the year, just after the holidays, and they were saying that their professional indemnity insurers were worried about some of the work that they were doing. The insurer was saying, we're concerned that a lot of your work involves international clients and conveyancing clients that you're not seeing. And what we want you to do is we want you to start looking for more work that's resi conveyancing, where clients are actually coming into your office, sort of local work. And we want to see you reducing the amount of international work you're doing because it's more vulnerable to money laundering, more risk associated with claims and fraud, etc. So again, the firm created a policy to say, right, 50% of our resi conveyancing is going to be work for clients within a 20-mile radius of our offices. And 25% of our work is going to involve clients actually coming into the office to see fee earners, etc. Well, if you're changing the amount of work you're doing, the nature of the work you're doing, the type of clients that you're acting for, you need to revise your policies. I was looking at a firm recently that was subject to disciplinary proceedings, and the firm had a money laundering policy that I think was created in 2013, and it hadn't been changed. And I think it was the SRA, Solicitors Regulation Authority, that inspected the firm, and they were hauled before the Solicitors Disciplinary Tribunal on the basis this is professional misconduct. If you have policies and procedures, you've got to revise them. There have been numerous revisions to money laundering and money laundering regulations. Your policies have to be updated to confirm consistency with current regulation. So again, having policies, undertaking risk assessments, etc. Two things. One, keep them under review. And if you have a policy, make sure it's adopted by everyone and there's evidence on file. Funny story to tell you about. I'm doing some more consultancy work for a firm that has 6 branch offices. And when I first started doing work for this particular firm, they said, be aware, Ian, that each of our branch offices has a different form of report on title. So there are 6 model forms of report on title that our firm use. Well, immediately alarm bells ring. Professional insurers don't like that. If you're a firm with a number of branch offices, your insurers will expect that you have a standard form of report on title for particular transactions. So I said, we've got to standardize the report on title for all the offices. And then on doing work on each individual office, it transpired that a number of fee earners in each office had their own form of report on title. So you had 6 major forms of report on title, and then each office might have 3 or 4 variations of that. So it transpired that there's over 30 different forms of report on title that the firm was using. And I said, the SRA won't like that, CQS won't like that, and your professional body and insurer won't like it. Standardization is important. As far as standardization is concerned, have you seen and do you use reports on title that are sort of using technology to migrate data from searches direct into the report? Anyone using that, or anyone seen that? It's quite the thing in England, not quite the thing in Scotland or in Northern Ireland as yet, but it's coming. And firms seem to be making sort of bounding leaps, as it were, with regard to the use of technology and facilitating the migration of data into a report on title. Great idea, to be honest with you, as long as you personalize the report on title, as long as you check the data that's being migrated into the report on title for accuracy. But one of the things that technology, artificial intelligence is doing is allowing conveyancers more time to deal with the nightmare or tricky issues, and also enabling fee earners, or should be enabling fee earners, to spend more time what I classify as client handholding, telling the client about, look, this is an area, this is a problem, this is a risk, this is the solution to the problem, or these are the solutions to the problem, and just guiding the client through the process. As I say, I class that as hand-holding. Client care, perhaps, if you're going to be a bit more sophisticated than me. My last topic for today is money laundering and best practice with regard to money laundering. Astounding. The other week, last week, I went to a garage with my partner because she wanted to buy a car. I was talking to the salesman who was just in the process of buying a house, and he was bleating about money laundering checks. So he was explaining about his deposit, the fact that I think a member of his family was gifting him some money for the purchase, and the fact that his solicitors had asked the third party to confirm where they were getting the money from that they were gifting to the nephew for the purchase, asking him to prove where he got his savings from, etc., etc. A huge barrage of requests for information in order for his solicitors to comply with their duties in connection with money laundering. And the thing that was quite bizarre is that he then said to my partner, well, how are you paying for the car? And a significant deposit was required relating to it. And advised, the salesman was advised, well, we'll just transfer the money over. No checks, no issues, no. Where do you get that money from? Nothing. So ridiculous. Money laundering is an issue. As a professional person, as a resi conveyancer, as a solicitor, working for a firm of solicitors, or whatever your status as a conveyancer, you owe a duty to your professional body. You also owe a duty to ensure that criminality is kept out of the conveyancing process. Conveyancing is a great way of washing money that's been obtained through criminality. And therefore, with regard to money laundering, there are a number of things. One, your firm should have a policy with regard to money laundering. Two, that policy should promote flexibility. So if you have acted for Mr. and Mrs. Jones for the last 20 years in connection with 6 sales and purchases, Mr. and Mrs. Jones live very close to your office, always attend your office on every occasion that a transaction is being undertaken, and are both salaried employees of the local authority or of some form of public body, then from a risk perspective with regard to money laundering, they have to be regarded as relatively low risk. If, on the other hand, you've had instructions from a new client who's based in Dubai, who's a self-employed marketing consultant, technology guru, whatever they'll call it, social influencer, whatever it is, okay, you'd have to say that their risk profile is significantly greater than our dear friends Mr. and Mrs. Jones. So you've got to have a policy that deals with those different levels of risk. There are products that you can acquire, the software that you can use. There are companies that will assist you with regard to money laundering. But at the end of the day, and money laundering checks, but at the end of the day, it's you and it's your professional reputation that's at stake. Next point with regard to money laundering, it's all well and good doing checks, fraud checks, risk checks, AML checks, etc. When you're onboarding the client, do you review those checks as the transaction progresses? Should you review those checks as the transaction progresses? The answer to both of those questions is an emphatic yes. So let me put two scenarios to you and see what you think. So Lynn, can I ask you this question? I'm a client of yours. You're doing money laundering checks with regard to me. I'm telling you that I'm putting £40,000 worth of savings into my purchase. Hopefully, you're going to ask me, Ian, where do you get the £40,000 from? And I say to you, well, 5 years ago, I received an inheritance from a great aunt of £20,000. The balance I've saved monthly out of my salary. Let's assume I'm low risk. You've acted for me before on a number of occasions. It might be that you say to me, well, all right, Ian, can I see the bank statement or the savings account where the £40,000 is currently lodged? You might say, Ian, can you provide me with some proof that you received that inheritance from your great aunt 5 years ago or 10 years ago? If I'm saying to you, I'm saving, £500 a month and have done so for the last 15, 20 years or whatever, you might say, well, all right, Ian, can you provide me with a bank statement for September 2021? And can you provide me another statement for June 2023? Just snapshots showing savings, money being saved or being transferred from a current account into a savings account. Okay, it wouldn't be necessary, it would be overkill in those circumstances to say, right, I need to see the probate of your great aunt, I need to see the estate accounts of the great aunt if you've got them, I need to see the money coming from the probate account of great aunt solicitors into your current account and then your savings account. I need to see every bank statement that you've got going back 10 years showing you saving this £500 a month. That's overkill, okay? If, on the other hand, we've got a client that we've never acted for before, who's an international client and who's self-employed, etc., and has no track record with our firm, and he or she tells us that he's being gifted, £50,000 by a girlfriend who's based in Argentina, then again, it might be that we want a lot more information about client and also Argentinian girlfriend. And £50,000, where is it coming from in Argentina, which bank, etc. And there could be a lot more investigative work that would be prudent and necessary in those circumstances. And we've got the whole spectrum of clients in between, haven't we? So yes, we have a policy. Yes, we keep our policy under review. But at the same time, we risk assess clients, risk assess funds as the transaction progresses. Does anyone have any questions relating to any of that? Has anyone got any topics that they'd like to explore for the remainder? We've only got 2 or 3 minutes before we finish today. I'm conscious of the fact that I've been droning on, as usual, for nearly an hour now. Remember, the whole purpose of these webinars is to assist you. So what I'd like to do for the next one is to have topics that you would like to discuss. Now, can I tell you that we do forums in England and Wales on resi, commercial, local authority lawyers, or building safety act stuff, all manner of different things. We also do a webinar of this nature in Scotland, and it's amazing the sort of topics that people ask for. So, for example, someone asked on one occasion about search providers. We're thinking about changing search provider from X to Y. What does everybody else think? Scotland, we had an inquiry from someone who was saying, we're interested in buying a case management system. Can you recommend, or has anyone used any case management systems? We get professional bodies coming along, we get search providers, we get registries, land registry, etc., wanting to come along and talk about topics. So the whole purpose of the webinar is to meet your requirements, not for me to say this is what I think we should be talking about. But for the purposes of today, at the start of the new year, we thought that was it, and we haven't had anything from anyone to suggest this is a topic for us. But again, I repeat, the idea is you fire the topics at us and we discuss them during the webinar. So before we finish today, a few questions. 1, has this been useful? 2, are there any topics that you'd like us to explore in the future? 3, are there any speakers that you'd like us to organise to come along? 4, are you interested in a face-to-face event at some point later in the year, probably in Belfast? And the next point is, if you have any questions or queries with regard to Stewart Title, you've now got 3 experts from Stewart Title in attendance today, happy to take your questions. So anyone got any comments? Again, you can use the chat facility. Jeremy, thank you. Model co-ownership questionnaire. Jeremy, happy to oblige. Jeremy, what I'll do is I'll put my email address in the chat box. In fact, what we can do, I think, is, let's see.
Mike.
Let's get rid of that call. Bear with me. We've got Stewart Title there, contact details, and my details. So, Jeremy, drop me a note to the email address, and I'll get that information sent to you. Jeremy, useful. Jeremy, do you have any
Ian,
questions?
sorry to interrupt.
Yeah.
We've had a
Yes.
couple of requests for that. So I wonder
Yeah.
if you're happy with it,
Sent to
you send me a copy and we'll send
Yeah,
it to everyone who's
absolutely.
attended. Will that
Brilliant.
work?
Great. Yeah, great idea, Robert. Happy to do that. Thanks for that, Robert. So yeah, Jeremy, we'll get that sorted out. Jeremy, does co-ownership cause issues for you? Would you like more information on it? Because again, I've just scampered through some points. There's loads of other stuff I can talk about relating to co-ownership. And anyone else got any comments to make? Patricia, anyone? Jerry? Do drop me a note or drop Robert a note if you have any topics that you'd like us to explore next time. All that's left for me to do is to thank you very much indeed for coming along today and giving up your time. Massive thank you to Robert, Liz and John from Stewart Title for coming along. Massive thank you to Stewart Title generally for organising this event and allowing me an opportunity to speak to you. Have a lovely afternoon. Stay safe. We'll speak soon. And as I say, any topics, any speakers, anything else you'd like to know, drop me a note. I'll assist. Any questions or queries concerning Stewart Title's defective title insurance product portfolio, contact them. On that note, Robert, thank you. Everybody else, thank you for coming along. Stay safe. Speak soon. Thank you. Bye-bye.